Hi, this is Paul McConnell from the McConnell Family Law Group. I'm going to talk to you about binding arbitration. Now listen, most cases resolve through settlement, 95+% resolve through negotiated settlement, but some cases don't. And in those cases, if you need a trial, there's something called binding arbitration that may be a good alternative. Like anything in life, there's pros and cons to anything. Some of the benefits of binding arbitration include you'll be in a private setting as opposed to a sterile courthouse. You get to control the schedule and the calendar, working with the other side of what works best for the parties and the attorneys, as well as the person that you've hired as the arbitration. It'll be a lot quicker than relying on the courts to try to get a trial date, which may be a year or more before you can even get on the trial court's calendar. You'll know who the judge is. There's 4, 5, 6 retired judges that have about 80% of the market share. We all know who they are, and they're all excellent. Lots of experience in divorce and matrimonial matters, and you can be assured you're going to get a reasonable outcome from them. Juxtaposed with relying on the trial court bench, there's excellent judges that sit on the trial court bench, but you don't even know who your judge is going to be off until a week before the trial. And it may not be somebody that's really experienced. It could be somebody that's brand new to the bench, for example. So that's another benefit of private arbitration, is knowing who the judge is. You get to talk with the other side and decide what the rules are going to be. Are you going to adopt all the rules of evidence and have them be applicable, or not applicable at all, and just admit more evidence, more exhibits and the like? It's going to be quicker. As I said, you'll get dates much sooner, and it's going to proceed more methodically. For example, you'll get either consecutive days if you need them, and you'll be in and out and done. As, again, juxtaposed with the trial court, if you have a day dedicated to yourself and you don't finish that day, you may come back a month later. And there's typically no interruptions throughout the day. You're focused, everybody's focused on your case. Now there's also some downsides. That is, obviously, the cost. You have to retain the private judge at $400, $500, $600 an hour. That's going to cost $4,000, $5,000, $6,000 for a one-day arbitration. Now there is some cost savings to be had when juxtaposed against the trial court to offset that to a degree, but there's no question it is an additional cost. Also, there's not going to be any appeal. You're not going to be able to appeal a final decision by an arbitrator, not with any hope of having any success in any event. There's pros and cons to that. The good thing about not having an appeal is you really do have finality. Private arbitration in Connecticut is governed by Connecticut General Statute 52 TAC 408. Basically, in a nutshell, there are certain documents, forms, procedures that need to be followed. There's going to be an arbitration agreement that the parties need to read through and execute. The arbitrator is going to require that the parties sign an affidavit that they've read the agreement and they've reviewed it with their counsel, and there's follow-up documents that need to be filed with the court and the like. But in the end, the decision that's issued by typically a retired judge is going to be final, and you can rest assured that it's going to be reasonable as well. If you have any additional questions, please contact us.